You may be seated. Good morning. This is the second day of oral arguments for the South Dakota Supreme Court here at the South Dakota State University campus. We appreciate the campus hosting us this week as we hear cases. We have a number of high school students here today, and I just want to mention some of the high schools that are present here today. We have students from DeSmet, Henry, Lake Preston, Marion, Rutland, Sanborn, Sioux Valley, Summit, and Wilmot. So thank you for being here, and we hope you find the arguments interesting this morning. The first case set for argument this morning is State of South Dakota versus Raymond Smith. For the appellant, we have Manuel DeCastro Jr., who will be arguing, and for the appellee, State of South Dakota, we have Stephen Gamar, who will be arguing. Each side will have 15 minutes for your initial argument, and then Mr. DeCastro, you'll have a 5-minute rebuttal argument. So with that, Mr. DeCastro, you may proceed with your argument this morning.
Mr. Chief Justice, Court, Counsel, my name is Manny DeCastro, and I represent Ramon Smith in this case. We have 4 issues to discuss today, but before we start with that, I'd like to briefly touch on the facts. Back on June 7th, Ramon had come to Sioux Falls to visit his sister Martise and her girlfriend Christina Haney. He was there to pick up a vehicle from his sister. That evening, they'd gone down to Pave in Sioux Falls, and there was some issues that Ramon didn't know about that were going on. The next day, there was an issue at this apartment complex on Cliff where one of the people came over and was basically pounding on the house, starting some confrontation, and the girls got upset about it, and they went over to a house, which was the house of Paris Maccabee, who was Jasmine's mother, who was involved in this altercation with Christina Haney. And it was basically to start as a Facebook-type feud between some girls. Ramon didn't know about this. After that happened and they'd gone over there, Joseph Allen, who was over at the house, Paris wasn't there. Ramon's sister had kicked in a fan and caused some more disturbance over there. And Joe Allen got some other people together, and what we had described at the trial was they got kind of an angry mob of about 7 or 8 people to come over to the house where Ramon, Martise Sadler, and Christina Haney were, as well as LJ Jr., who was Larry Carr, who's the decedent in this case, his son. It was LJ, they call him LJ, it was Larry Carr III. When that happened, they all gathered outside. There was a retaining wall where these individuals gathered. When they came over, one of the Allens went into the apartment building because the door had been accidentally propped open with a rug that was left, a mat. Usually it was locked. It was an outside door, a security door. He went in, he was banging on the house, banging on the door, calling Christina various names, come outside, bitch, various things like that. Prior to that, they'd actually sent some videos, Snapchat videos with guns threatening them. And then Ramon was in the house and he saw the Snapchat video with the threats, but he didn't really know what was going on because he wasn't involved in this Facebook feud or any of this stuff. But when he looked outside, he saw all these individuals sitting on the wall. One of the individuals that had gone outside was Larry Carr Jr., who's the decedent in this case, and he'd gone out because he saw an individual that he worked with out there, David Juan Brown. He saw him, he went out just to talk to him. And as this was going on, LJ went outside because he saw his dad outside and knew maybe something bad was going to happen. So he went out to try to tell his dad to go back inside to the house because of the threats with the guns and the threats on the Snapchat and all of that. Ramon was looking out and saw the people, and as he had said, he didn't testify at trial, but he'd given a statement to police when he got arrested months later up in Minnesota, that he was scared. He didn't know what to do. He'd seen, the pictures of the guns. He'd seen the threats that they were coming to get him. But he didn't know any of these people, and it was all guys that were sitting outside, so he figured he'd go outside. What he stated, he was going to go outside because he didn't know any of them and try to defuse this situation. So he went outside initially, and as seen in the video, he had his hands up. But before he went outside, he had grabbed a gun that was up in the cupboard. It was his sister's gun, Martise Sadler. It was a pistol, and tucked it in the back of his waistband. When he went outside to try to defuse this situation with his hands up, Josh Allen had said something to the effect of, is this nigga that's causing the trouble? And someone said yes, and in the video you can see the Allen boy charging at Ramon. And at that time, Ramon pulled out his pistol, shot the individual charging at him, who was Joshua Allen. He also shot, because all the other people got off the retaining wall, he also shot over to Javon Allen. As he saw Javon kind of reaching down, he had a satchel with him, which later trial showed that he had a pistol in that satchel as well, and he got shot in the head. Larry Carr was standing next to him. Larry was shot in the stomach. And after that happened, as the video shows from Dakota Auto Parts, which was across the street on Cliff Ave, you can see individuals scatter in all sorts of directions. Some individuals went north on Cliff Ave, and you could see Ramon shooting over the top of them on Cliff Ave. There was an angle, it was an angled parking lot. He was shooting above them, but he, in his statement, said he was still scared about them coming back and threatening him. Detective Sarda, which was noteworthy at trial, had indicated when the individuals, they'd originally met at McDonald's before they came over to this North Cliff area, to the apartment complex. They parked blocks away, which was noteworthy, as we felt that they were trying to hide their identities, conceal themselves from coming over, conceal themselves from anyone seeing them coming over. And as Detective Sarda indicated in the video, one of those individuals went around to the back, up North Cliff. There was a tree that was kind of towards the back of the apartment complex, which was the only other exit to get out of that complex besides the front door that Ramon went out of. So it was clear that they were trying to block that exit as well. And it was also noteworthy that none of them had any cell phones on them. I mean, when the Allen brothers went to the hospital, they didn't have any cell phones on them. As we pointed out at trial, I don't know any kids that don't have cell phones these days, and it was clear to us that they were trying to hide what they were doing. Unfortunately, after Larry Carr was hit, the two Allen brothers jumped in a pickup, a vehicle, and they were taken to the hospital by just kind of a bystander that was driving down Cliff Ave. Larry Carr Jr.
Counsel?
Yes.
I'm sorry to interrupt you, but I'm really afraid you're going to run out of your time here, and we are familiar with the facts.
Okay, that's fine.
Could you please proceed your legal argument?
Sure. So we raised 4 issues that we're going to discuss here today. The first one was that the trial court erred in not allowing a hearing regarding statutory immunity. Now, as everyone's aware, House Bill 1212 was signed by Governor Noem. It went into effect July 1st, 2021. This case was tried August 16th to August 26th, 2021. After that law went into effect regarding the statutory immunity, we had filed a motion to dismiss under the statutory immunity statute with Judge Zell. Judge Zell, and we requested a hearing. Judge Zell denied that request and said that the statute wasn't retroactive. He found that the statute was not procedural in nature, but was substantive in nature, and therefore not retroactive.
Do you agree on appeal that really the issue boils down to whether or not it's a substantive change or a procedural change in terms of retroactivity?
I do.
That's what the issue boils down to.
Yes, I agree with that, Chief Justice.
Why is this in your view, procedural, not substantive?
Well, when you look at justifiable homicide or homicide that's lawful in South Dakota, for years, I mean, we've had lawful self-defense. We've had lawful justifiable homicide. I mean, when you look at the jury instructions, I mean, even the jury instructions that Judge Zell gave in this case that are based on the law prior to that July 1st, 2021, one of the elements that the state had to prove that was the killing was not lawful. That's one of the elements. So we have all those statutes that were already in place that talk about the lawfulness. In this case, the only thing that changed, sure, the statutes, the numbers changed and they got combined, but basically they're all still the same. The only thing that changed was there was a mechanism for the defense to come in and say, hey, we believe that this statutory immunity applies. We believe that we get a hearing based on this. And, you know, this court has never, since this to me is the first time this court's addressed this issue. And when you look at Wyoming, I think Kansas, Kentucky, and I think Florida, for a few, they all require that someone has a statutory immunity hearing. So we asked Judge Zell for that hearing, but like I said, in this case, the only thing that changed in our view is that procedural mechanism to come in and ask for the statutory immunity hearing, have that prior to any sort of trial, which obviously makes things much more efficient. And that's it. I mean, that's a procedural change in our mind. It's not substantive. Nothing in the law has changed substantively. Just a procedural mechanism came into place that said, hey, you get this hearing up front before trial, and the court will decide that.
Well, of course,
Go ahead.
with the self-defense statutes, though, those didn't come along with a complete immunity from prosecution. Why isn't that a substantive matter?
Well, and there is, I mean, I agree, there's a slight difference between justifiable homicide and self-defense. You know, and in this case, really, we argued obviously self-defense, but we also did argue justifiable homicide because Smith was in a dwelling where he had a right to be, which is one of the issues.
And I think maybe you misunderstood my question. So those are things that can be argued to a jury, but of course the difference here is you can't even proceed. You can't proceed with the prosecution. You're immune from that. That's a change, certainly.
It's a procedural change. It's a procedural change that you get that the defense gets a hearing like that ahead of time. There's nothing substantive that changed about that. It's a procedural mechanism that came into place where you can come in and argue that the case should be dismissed. And then it also, the next question then is, you know, what's the burden of proof on a hearing like that?
Before we get to that, because I think that may have been resolved, don't we have to apply our test? We've held, and we have a standard. Our standard is that as it relates to criminal law and procedure, Substantive law is law that declares what acts and crimes are prescribed and prescribes the punishment, whereas procedural law, which is the distinction that we're talking about, is that which provides or regulates the steps by which one who violates a criminal statute is punished. Do we have to apply that, or do we go in search of some more generic version of what's substantive and what's procedural? Because if we're restricted to that, that could affect the outcome.
Well, but Justice Alter, when you think about it, there's nothing in 2218-4.8 that prescribes any type of punishment.
No, you might be right. That's what I'm saying. Is that the test? Is that the standard?
Yes. And there's nothing in there that prescribes any type of punishment. There's nothing that's changed about it.
Doesn't say what acts are crimes and what aren't crimes. Doesn't prescribe any punishment for them.
Right.
Those were the two criteria for a substantive change.
Right.
So, counsel, states have taken different approaches, as you noted, in dealing with the stand your ground type statutes. If indeed this was procedural and you were denied the statutory hearing, how was your client prejudiced at this phase? There's now been a full jury trial, and he was convicted beyond a reasonable doubt. At this point, how has your client been prejudiced if indeed you were denied the statutory hearing?
Well, obviously I've thought about that as well. From our standpoint, it would be a strict legal question for the trial court to decide. One judge decides legally whether we, made our case or didn't make our case. I mean, obviously, this is one of our issues. I think cumulatively, all our issues require us to get a new trial.
But it's not just a legal determination. There's judicial fact-finding involved,
Sure.
too. Yeah.
I agree with that, Justice Salter, yes.
Yeah.
You apply the facts to the law and then decide whether.
And there could be some conflicts. Who did what at what point and how the sequence of events unfolded. So in this type of a hearing, it would all be laid out essentially in the same way it would be laid out at the trial.
It could be. Sometimes there is, Justice Salter, sometimes with a court trial, maybe some things come in that don't come in at a jury trial or something like that because, sometimes attorneys let in, some other evidence or something like that maybe wouldn't come in at a jury trial because the trial court, being in the trial court, knows which evidence to consider, which evidence not to consider, et cetera. But yeah, I mean, I think we were required to have that hearing. I think it's simply procedural in nature. There's nothing that changes, the statutes. There's nothing that changes the penalties. There's nothing that changes the crimes.
Mr. DeCastro, I want to move you to your issue with respect to this testimony from the law enforcement officer who testified real briefly that the defendant was a convicted felon and couldn't possess a gun. Judge allowed that testimony to come in. Tell me why you think that ruling was erroneous.
Okay. So initially, Ramon was charged in I think it was an 18-count indictment, if I remember right. Count 19-count indictment, excuse me. Count 17 was the possession of a firearm by a convicted felon, crime of violence, and it laid out, namely, that he'd been convicted of murder in the second degree before. We had filed a motion to sever back on August 28th, 2020. We filed a brief September 21st, 2020, and there was a motion hearing in front of Judge Sabers the 23rd, 2020. And the state at that time didn't even challenge us with regard to severing count 17, which, admittedly was a surprise to us. But they didn't challenge that. Ultimately, they dismissed count 17 right before trial, July 22nd, but for all intents and purposes, it was going to be dismissed September 23rd, or was dismissed back then. Okay, but the dismissal, the formal dismissal was July 22nd. So we get into this trial where that charge is dismissed, so we're just dealing with everything else. We'd file a motion in limine as well regarding his a prior status of being released from prison, et cetera. So we get through trial, we start picking the jury, okay? Which everyone knows jury selection is important. And one of the questions, I did the first voir dire, and I asked about, there's people in South Dakota that like guns, there's people that don't like guns, et cetera. And I asked about that and whether people should own guns, and a lot of the voir dire people said if they can lawfully possess it. Well, had we known that this testimony was coming in, I certainly would have addressed that in voir dire, because that was a huge issue. In fact, I've tried a murder case since this case that had that same charge, and I didn't even ask to sever it because I was going to handle it in voir dire because of what happened in this case. So then Ms. Reynolds, who tried the case with me, that happened. Ms. Trankel, who was the prosecutor, said, well, we opened the door. Well, we never followed up on that. We never said anything about that. So we didn't open the door, and Judge Zell didn't think we opened the door. So we get 5, 6, whatever days into this trial, and then the prosecution on a Friday or Thursday files a motion that says, hey, if we're raising, self-defense and want these instructions, well, they should be able to bring in that he's not allowed to have the gun. Well, we're halfway through the trial, and we come to that Monday. We briefed it over the weekend, okay? And we had gone through all the stuff, that it's overly prejudicial. We'd gone through the case law as far as Bertzloff, as far as Pellegrino, as far as Andrews, and saying, hey, these are all different scenarios, but this court has consistently held when a homicide defendant raises self-defense or justification, the state must prove beyond a reasonable doubt it wasn't without authority of law, okay, or it wasn't lawful. So the only thing that the jury had to decide was this killing lawful or was it unlawful? If they decide he's not guilty, it was lawful. If he did decide he's guilty, well, it was unlawful. So this had absolutely, bringing in Detective Jacob Harris, I think was their last witness. It was, I think, their last question to him with a scenario that said, was Mr. Smith allowed to possess that gun on this time? And Detective Harris said no. Now, the court gave a limiting instruction, but that didn't cure anything, okay? I mean, that didn't cure anything. That was, the evidence was irrelevant. The state had already agreed to sever that count, and then somehow they lay in the weeds and come in and kind of backdoor what we thought to get that in, and we thought that that was certainly irrelevant, overly prejudicial, and it didn't go to anything as far as whether this killing was lawful or not.
Mr. DeGasper, I'm going to stop you there since your time's up, but I'll obviously you can reserve all of your issues for rebuttal.
Okay. Thank you, Mr. Chief Justice.
Mr. Gaymer, you may proceed.
May it please the court, counsel. This is a murder case that started on June 8th of 2019. On that day, defendant walked out of the apartment building at 120 North Cliff in Sioux Falls, and within seconds of stepping outside, drew a pistol and began shooting into a group of people, none of whom had a weapon drawn.
Mr. Gaymer, can you win on the retroactivity issue if we apply the test that I spoke about with Mr. DeCastro, which is to say substantive laws are ones that declare acts that are crimes, what acts are crimes and what the punishments are. Procedural laws, by contrast, are those which regulate the steps by which one who violates the law is punished. Can you win under that test, or do you need to expand that test or look to South Carolina for a different test? How do you win on that issue?
Your Honor, the state would win under that test.
How?
while it doesn't explicitly limit certain acts, the statute grants an immunity it allows, if immunity is claimed early enough, it allows certain acts to not even be charged out anymore under the plain language of the statute if somebody is found immune from criminal prosecution.
And that would be saying that it's not a crime? Because the standard is it declares what acts are crimes and prescribes the punishment. So it's clearly not a punishment statute, doesn't seem like. So you're saying the immunity statute removes this from the realm of those acts that are criminal?
If the person is found to be immune, then yes, that act would not be a criminal act anymore.
Or at least it can't be prosecuted for. That may be a fine distinction.
Yeah, and cannot be prosecuted.
So do we need to, I'm asking because I want to know what you think we need to do. Is that test serviceable? Is it not? Does it need to be, adjusted through a decisional law? What do we need, in your view?
Well, Your Honor, that test is a serviceable test, and I think it's also important to note that the statute also does have elements in it that are not, the immunity does carry parts that are not strictly criminal, such as being able to be immune from any type of civil liability for those acts if a person is found immune. And in addition, if a person is found immune, then the court can award attorney's fees and compensation for loss of income for a person who has been found immune. And this court in the West v. John Morrill case also said that substantive rights are not to be applied retroactively, and that is exactly what immunity is. It's a substantive right. And going back to that, Florida, where...
You say immunity is a substantive right. How do we know that? Do we have some case law or law in South Dakota that says that? Or how do you know that immunity is a substantive right?
Well, this court has not ruled that the state was able to find on this particular issue, but Florida, where the South Dakota legislature pulled the immunity statute from, has ruled on this issue. And in the case of Dennis v. State, the Florida Supreme Court found that immunity was a substantive right. And they considered it a substantive right to not be arrested, detained, charged, or prosecuted as the result of the use of legally justified force. And in the case of Love v. State, they affirmed that distinction, that immunity was a substantive right.
And that would, so if we accept that argument, then we would have to adjust our test, and our test would be maybe a little too restrictive, and it would look more, in your view, like Florida.
Yes, Your Honor.
Okay.
A good example of a procedural change to the law is actually found in the case of Love v. State, which in that case the Florida legislature amended their immunity statute with a bill that established a burden of proof. And using the same definitions of criminal, substantive, and procedural law that this court used, we're talking about now, the Florida Supreme Court found that that burden of proof amendment was a procedural change to the law, that it regulates the steps by which one who violates the law is punished. And later on in that same opinion, they affirmed the right to immunity was a substantive right. And finally, and as Justice Kern noted, even if the statute is found to be retroactive, there's no need to apply it here because the defendant was already found guilty in this case beyond a reasonable doubt. He was given his jury trial. He was allowed to argue self-defense, and the jury rebutted that presumption of self-defense when they found him guilty. His claim was also thoroughly examined by the trial court on 2 separate motions for judgment of acquittal, as well as a motion to set aside the guilty verdict. Even the case that defendant cited in his brief, the Kentucky case that found their immunity statute was a procedural change, even in that case, the Kentucky Supreme Court did not apply immunity to Rogers' case.
If we were to accept that harmless error argument, then should we, perhaps out of prudence or restraint, not address the merits of the retroactivity issue? Or are there other cases that we don't have in front of us right now that are out there that could be impacted and would benefit from a merits ruling on the retroactivity issue? Because if there aren't, then maybe if the harmless error argument that you're suggesting holds water, maybe, as I say, out of prudence or restraint, we just don't go there.
Yes, Your Honor, there could be other cases out there that may require a ruling on the merits.
That's your sense, that there may be others?
But that would be a determination that this court would have to make in determining what they would like to address.
Counsel, could you move now to the second issue with regard to the testimony that came in on the defendant's unlawful possession of a firearm? It appears from this court's past cases, at least a couple of them, that the unlawful possession of a firearm in and of itself is not an impediment to raise a self-defense claim.
Yes.
Do you agree with that?
That is correct, Your Honor.
So how then was that relevant in this case, and particularly given the sequence of events that Mr. DeCastro laid out, where there was a charge, an unlawful possession charge that was severed, it was dismissed? Explain to me how that then was relevant in this case, in what was tried.
Sure. So it was relevant, Your Honor, because the circuit court found that it allowed the jury to consider, in all the circumstances surrounding whether the defendant was justified in using deadly force. In this case, the jury was instructed with justifiable homicide, and with that standard, they needed to not only see what the defendant saw in the situation he was in, but they also needed to know what the defendant knew.
Well, so that's what I'm struggling with here. So there are standards set out for what constitutes self-defense and a reasonable perception of an imminent threat. So how does whether or not you possess the gun lawfully or unlawfully relate to your perception of the immediate threat that would allow you to use self-defense? I'm not getting the logical connection there.
Well, Your Honor, with that, the jury could have taken that information as a factor any which way. They could have determined that the defendant was so scared of the threat that even though he knew he could not possess a gun, he still picked up that gun to defend himself. So, so the state is offering this evidence. That would seem to weigh in favor of the defendant's argument, wouldn't it? It is just a potential way that the jury could have interpreted that information.
Is that the way it was? Was it argued that way to the jury?
I do not recall right offhand, Your Honor.
Mr. DeCastro has talked about how his client was prejudiced by that. Namely, he didn't have notice that this testimony would come in at trial when he was picking the jury. I'd like to hear your response to that.
Your Honor, I believe the state did file notice at some point. I can't remember exactly when right offhand, but in regards to the jury selection, all of the jury panels were passed for cause, and as far as the state's review of voir dire, those jurors that audibly expressed concerns about the legality of lawfully owning firearms were not on the final jury panel. And further, on that point, juries are expected or presumed to understand and follow the trial court's instructions on that regard.
But Mr. DeCastro's argument is that he would have approached voir dire differently had he known that the state was going to present this evidence before the jury. Address that, please.
Yes, Your Honor. That still does not, in the state's view, rise to the level of prejudice which would have, in all probability, produced an effect on the jury's verdict. Because even if the testimony about the defendant was precluded from owning a firearm, even if that was kept out, there was still a multitude of other evidence in the record that they could have used to convict him, to have convict defendant. There was more than sufficient evidence in the record. So any potential prejudice would be minimal, would have been very minimal. And further on that point, this court has said that in the evidentiary context, for an abuse of discretion, a trial court must misapply a rule of evidence. And as far as the state has seen, to the state's knowledge, the defendant has not specifically alleged what rule of evidence here was actually misapplied. As I mentioned, the circuit court found this evidence relevant as a factor that the jury was able to consider. It was just one of many factors surrounding the defendant's use of deadly force.
Well, of course, even if it is, we just apply the 401 and 403 rules, even if there was some relevance, minimal relevance, the court still has to balance the potential prejudicial effect of telling the jury that this is a person who's unlawfully in possession of this firearm. Was there some potential for an unfair prejudice there?
Not there, Your Honor. Not with that, because in the jury instruction, the circuit court gave a limiting instruction to the jury before that evidence came in.
What did it say?
It said two things. One, that the jury was only allowed to consider it for whether the defendant was acting reasonably under the circumstances. And two, it said a person prohibited from possessing a firearm can still do so if it is justified under the circumstances. And I see my
How was
time.
the oh, go ahead, please. I'm good, thank you.
Well, let me see, how much time does the state, what's that? 7 minutes left? You still have some time.
Okay.
It did seem to go
Justice
fast.
Simpson. Yeah.
I think the light's not working.
As to that first part of that limiting instruction, can you, as they say, unpack that a little bit for me? What was the reasonableness inquiry that was at the heart of that in your view?
Again, Justice Salter, I believe, or the state believes the reasonableness inquiry was just the circuit court wanted the jury to have all the information surrounding the use of whether the defendant was justified in using deadly force.
Yeah, so
And
reasonableness then, let me ask it this way. So reasonableness in terms of his reasonable apprehension of the threat of deadly force?
yes.
How does that relate to that?
It relates because the jury was instructed to consider what the defendant knew at the time, and that
I saw that, state of mind.
the state of mind.
That could be a lot of things.
Yes.
So it should probably, don't you think, be connected to some of these inquiries. So in other words, if we're talking about justification, this reasonable apprehension, that you're in your perception that you're in fear or you're perceiving a threat of violent or a deadly force, I'm still having a hard time connecting up this evidence to that perception and the reasonableness of it, if that's what that instruction was driving at.
Yes, it was. The instruction was just to limit the jury's consideration of that evidence so that it wouldn't go into any other consideration other than the whether he was justified in using deadly force. And as I mentioned, that as we had previously discussed, it was the defendant's knowledge that he was unable to possess a firearm, and under the justifiable homicide jury instruction, the jury needed to consider what a reasonable person in defendant's position would have done, and that includes what the defendant knew.
Okay, thank you.
And further, getting to the rest of the evidence in this case, all of the evidence, when it is viewed in a light most favorable to the prosecution, is more than sufficient to sustain defendant's convictions and the jury's verdicts. The state had to prove 4 elements beyond a reasonable doubt in order to convict the defendant of second-degree murder. 2 of those elements are not in any real dispute. That defendant shot Larry Carr Jr. and that the defendant did not intend to kill Larry Carr Jr. The depraved mind element is also not in any real issue, because here we have a video of the defendant stepping outside and within a few seconds, within 4 seconds, pulling out a pistol and shooting into a group of people that testimony established did not have a weapon drawn. And in the case of Stone, this court said that intentionally shooting a victim at close range is a prima facie case of second-degree murder. So that establishes the defendant's depraved mind. And the question becomes whether he was justified in using deadly force here. And whether he was justified is a question for the jury, because the jury is in the best position to weigh the evidence in the testimony and the facts and circumstances of each case in order to come to a conclusion. And again, going back to the video evidence, the defendant steps outside and within seconds pulls out a pistol and shoots into this group of people. And after that initial volley, the defendant then and the group starts to scatter. The defendant then walks across the parking lot, levels off his arm, and fires more shots across Cliff Avenue, one of the busiest streets in Sioux Falls. As the jury was instructed, and this court said in the Cottier case, the responding force in a situation like this becomes limited to what would be reasonable under the circumstances. And the jury could have, even here, could have saw that and determined that the defendant's use of deadly force was not reasonable under those circumstances. Further, there were acts both before and after the shooting that establishes the defendant's intent and purpose. First is that when the 2 or 3 members of the group went inside the apartment, the video shows that they were only at the apartment door where defendant was for less than 20 seconds before they retreated out to the parking lot. In the testimony of Larry Carr III, or LJ Carr, also established defendant's mindset here. He said that when the group of people showed up, defendant picked up a gun and said that if he went outside, he was going to start shooting. And LJ took this threat seriously enough that he ran outside to the group to get his dad, Larry Carr Jr., away from the group of people. And unfortunately, defendant stayed true to his word here, because despite allegedly being scared, he willingly left a locked apartment with a gun, and within seconds of stepping outside, pulled that gun out and proceeded to shoot into this group of people. Further, after the shooting, within a minute after the shooting, the defendant fled in his Buick. He fled back to Minneapolis, but he didn't go home. He stayed in a hotel for a period of time. Defendant also cut off his dreadlocks. He changed his appearance. Finally, that Buick, the reason he came to Sioux Falls, was effectively abandoned. Defendant said he parked the car somewhere and it wasn't with him when he was picked up by law enforcement. And this evidence can be used not only to establish the defendant's mindset, but also to establish his consciousness of guilt, the evidence of flight or concealment. For the last issue on the mistrial, the state would rely on its briefing in this matter and would respectfully ask this court to affirm defendant's conviction. And if there are no further questions.
Thank you,
Thank you.
Mr. Gamer. Mr. Castro, you have a 5-minute rebuttal. You may proceed.
Thank you, Mr. Chief Justice. I know we talked quite a bit about this second issue with the firearm, and I just want to touch on some of the things that were said. I think we all know relevant evidence means evidence having a tendency to make existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Looking at the statutes in the crime that was charged, there's nothing that him not being able to possess that firearm has any tendency to prove whether this was a lawful act or not a lawful act. In fact, what happened after this evidence was brought in, and we talked about the procedure of it, after that was brought in, then the trial court went on after that, and like I said, we talked quite a bit about the Bertzloff case, the Pellegrino case, the Andrews case, and those were cases that talk about whether this evidence was relevant, if it was even timely told to us, whether it was relevant at trial. So you get the Andrews case, 2001 SD 31, where, you know, you got a young man who's upset, I believe, with his uncle, driving around drinking. He's got a shotgun, waving it around. So he was charged, I think, with, you know, possession of alcohol, firearm while intoxicated, etc. Vehicle pulls up next to them, gun goes off and kills him. Okay? They said that that was relevant because what he was doing at the time was unlawful. But we got to look at that case as well, because in that case they argued that that was excusable homicide, which is doing a lawful act with usual and ordinary caution. So in this case, we had argued about this issue coming in, or these facts coming in, and what the trial court did after the facts came in is actually gave a jury instruction that dovetailed into this issue regarding the burden that then we had on us to show that under the Delaveau case, which is, I believe it was out of one of the Carolinas, that under lawful present impending threat, so our client was under unlawful present impending threat. He didn't negligently or recklessly place himself in the situation. He had no other alternative, and there was a direct and causal relationship. Now that test, or those things were put on us, which if this evidence had come in, we wouldn't have had any of that. The jury just would have talked about, hey, was this a lawful killing or an unlawful killing? And the fact that he couldn't possess a firearm had absolutely nothing to do with that, but in fact made our burden different. And when you look at the cases that were cited by the trial court regarding that, those are all federal cases, felon possession of a firearm cases. The Delaveau case, I think the individual had gone into a crawl space, picked out a gun, shot outside, gone back in, was charged with felon in possession of a firearm, and wanted to use, you know, a self-defense thing with respect to that. So those are all distinguishable from what we have in this case, in our opinion, and those are things that we never would have had to deal with had A, we had noticed, we would have dealt with it differently, B, had it not come in. The jury answers the same questions, lawful, unlawful, that's it.
Counsel,
and this had nothing to do with anything.
I had asked counsel for the state how it was argued to the court, because it didn't seem like the state was making this goes to reasonableness and intent sort of argument, that they were arguing this would go to the lawfulness of the whether or not the self-defense was lawful, which doesn't really seem to comport with at least some of this court's cases. And the argument he made seemed to be more in line with something the defense would use it for, to argue. But what is your recollection of how this was presented to the court, the relevance issue?
My recollection is that the state had indicated if we were arguing self-defense, they thought they could bring in that he wasn't lawfully able to possess this, and then they argued that it was unlawful for him to even have it, and they argued the four factors that I just laid out. I know the state just argued about the limiting instruction, but when you look at the limiting instruction, which is on page 179, I think it's volume 6, it says, the state will offer evidence the defendant had been previously convicted of a felony offense which prohibits him from possessing a firearm. The defendant is only to be considered by you in determining whether the defendant was acting reasonably under the circumstances. Even a person prohibited from possessing a firearm can possess a firearm to defend themselves in certain circumstances, and it's to be considered for no other purpose, and is only one consideration for you to consider. So the trial court puts out there, A, they can't possess the firearm, and you got to consider whether it's reasonable for him to act the way he did, which goes straight to the lawfulness, which this was completely irrelevant under this court's precedence to whether it was lawful on what he did in these cases in killing Larry Carr.
And so if it was improperly admitted and this instruction was given, how is your client prejudiced?
Well, when we look at, Justice Kern, when we look at...
Mr. DeCastro, your time is up, but I'll let you finish that question. So go ahead and answer the question.
Okay. When we look at the evidence that was placed in the facts of what was going on in the case and whether it's acting lawful, certainly for the jury to hear and the questions they had in voir dire, that he couldn't possess this to begin with, I certainly think that that prejudiced the whole trial, and I certainly think we can't infer that the jury disregarded this. I don't think the court could have unrung the bell here, and I certainly think, looking at the totality of everything, that he was certainly prejudiced by the jury hearing that he could never possess it when it didn't have anything to do with the elements of the charges.
Thank you.
Thank you.
Thank you, counsel, for your arguments. The case is now submitted to the court. We'll be in recess.